The production of this show is made possible by the support of viewers like you. Please visit conversationsthatmatter.tv and become a subscriber. The views and opinions of guests on this show are not a reflection of the views of the management or staff of this channel. Welcome to Conversations That Matter. Each week we have a one-on-one, in-depth interview with a thought leader on one of the major topics that we believe is going to shape the future of British Columbia. Joining me now is Mike McNish. Mike, how are you?
Stu, good to see you.
Good to see you. The issue today is land claims, not just the Tsilhqot'in decision, but land claims in general. But the Tsilhqot'in decision has moved us towards having a conversation about what this means. Give us a little context about that case, and then tell us a bit about who is going to be occupying that seat once we get going here today.
You know, this is big. I think you've hit on that, Stu, and I think it's most important for the First Nations because this is really landmark in that we're taking the understanding of land rights from what was historically kind of a postage stamp approach. In other words, where are you now and what are you doing now? That's your land, to this much more expansive definition of land rights. So the court has said, the Supreme Court of Canada has basically said, we're going to go back historically, as far back as we can go, and listen to First Nations and understand the full geographic scope of where historically they hunted, they fished, they trapped. And remember, these are historically nomadic people, so they've been over very large swaths of British Columbia. And so now suddenly we have a Supreme Court decision that upholds this, again, expansive concept of land rights.
And it doesn't just say you have a legitimate claim. It's saying, yes, it's yours, here's the title.
That's right. You not only have claim to the land, but you now also have claim to decide how the land is used, how it's managed, and to economically benefit from the management of that land. So it's really provided, I think, a lot of clarity in one sense, if you ask First Nations, a lot of uncertainty if you ask other interests, like the economic community and even those in the provincial and federal government.
So our guest today is Grand Chief Stewart Phillip. Tell us a little bit about him.
This is someone who has been on the scene in terms of First Nations leadership for a long, long time. He was head of the Okanagan Nation Alliance for many, many years, comes from the Penticton Band originally, and is now in his fifth three-year term as the Grand Chief of the Union of BC Indigenous Chiefs. Now, the Grand Chief designation is not something we hear very often. This is a big deal, and this was given to him just this year, actually, by the Okanagan Nation Alliance in recognition of over 30 years of leadership. It has a really interesting personal story. He was taken from his Aboriginal parents as a very young boy, so he's very intimately and personally aware of the whole notion of personal freedom and has been a very essential person in the long-standing, what First Nations would call, struggle for the right to title.
There's a fascinating conversation that we had with him in September 2014. Let us now go to that conversation. Thank you for joining me. These are very interesting, and as you have noted, have the potential to be volatile times. What makes it so interesting right at the moment from your perspective in light of the Tsilhqot'in decision?
Well, I think one needs to understand we've been involved in this fight for 150 years. It's not a new issue. And the Tsilhqot'in decision is merely another Supreme Court decision that has come down in the favor of Indigenous peoples in the province of British Columbia, not unlike the Calder decision that came down 41 years ago, which really opened the door to the legal battle in the courts with respect to our unextinguished Aboriginal title interests in the land and resources within the province of British Columbia. There's been many, many Supreme Court decisions that have ruled in the favor of the native people of the province of BC.
Unextinguished, I think, is the key word there, isn't it?
Absolutely. Most Canadians don't appreciate the fact that throughout Canada we have a number of what are referred to as the numbered treaties, which represent an agreement between the Government of Canada, between the federal crown and the treaty people across this country and across the prairies, whereby they have certain arrangements and understandings with respect to their territories. British Columbia, by and large, does not feature any treaties. There is Treaty 8 spills over into the northeast of the province of British Columbia, and there are a number of Douglas treaties that were made under the auspices of Governor Douglas back in the day. But by and large, BC is Indian land.
Because that treaty process got abandoned going back to the 1890s, as I understand.
Well, BC has an interesting history. When it joined Confederation in 1871, it wasn't all that eager and willing to join Confederation. There were other considerations. I believe there were overtures made from the U.S. And the negotiations were very intense. And there's an Article of Union, the Article 13, which BC insisted be part of the arrangements. And Article 13 says, basically, that we can continue dispossessing and shafting the native people as we have in the past, because they did not, British Columbia did not want to follow suit with the other treaty-making arrangements that had happened across Canada, whereby I believe each man, woman, and child were allocated 650 acres. BC said, that's not going to happen in British Columbia, and if you don't agree to this provision, we're not going to join Confederation. So that set the stage for the long, protracted history of denial of Indigenous land rights or Aboriginal title in the province of British Columbia. And quite frankly, we've been fighting this issue ever since, and in the last 40-odd years, we've been slugging it out in the courts.
We'll come back to that in just a moment. Stay with us. The views and opinions of guests on this show are not a reflection of the views of the management or staff of this channel. So what's the province going to look like as we move forward? What does this decision mean in relations between First Nations that do not have treaties with the province of British Columbia? And then what does it mean as far as a business model that works for everyone involved?
Well, again, if one reflects on the number of Supreme Court decisions that have come down in the favor of the First Nations people in the province of British Columbia, one would expect that there would have been a significant policy shift on the part of the provincial government quite some time ago. However, that has not happened. The government continues to conduct business as usual and is very, very reluctant to move and take direction from the Supreme Court of Canada. And so at the moment, in spite of the multitude of court victories on behalf of First Nations, the government continues to take up unextinguished Aboriginal title lands and to offer permits and licenses to third-party interests, to industry, and so on and so forth, under the protest of First Nations people. The Tsilhqot'in decision is incredibly significant in terms of the nature and scope of the decision, without question, but the real issue is, will the Government of Canada and the province of British Columbia finally say it's time that we view this as an opportunity an opportunity for Canadians and British Columbians embrace this decision and ensure that we move forward in a manner that is in the best interests of all parties. Obviously, that hasn't happened. I know that the decision came down on June the 26th. Governments have admitted that it represents a loss with respect to the legal arguments that they put forward in the Supreme Court. Like many other Indigenous leaders, I was actually in the Supreme Court of Canada when the legal arguments were made by all parties. And we just had a meeting with Premier Clark and members of her cabinet last week. And the essence of the outcome of that meeting, although it was historic in nature, was the provincial officials at the end of the day said we're not there yet. So it's going to take a tremendous amount of hard work. I've said on many occasions, reconciling Aboriginal title interests with Crown interests and other interests is going to be extremely challenging. And I've said publicly, recognition is not for wimps.
Where are we at exactly right now? What is the province bringing to the table that you're saying not even close?
Well, the province really in reality isn't bringing anything to the table. They're, again, the Premier is a consummate communicator. She said all the right things. You know, she was quite emotional and made some very moving remarks, but at the end of the day there was really no commitment to undertake the challenge that is represented by the Tsilhqot'in case.
So when the province are talking to individual First Nations about, you know, okay, well here's how we settle that, are you saying that they're bringing virtually nothing to the table right at the moment?
Yes, that's it. I mean, we were expecting some, you know, some definitive statements. After all, this was a very decisive decision on the part of the Supreme Court. It was 8-0. And the Supreme Court was very clear. When our leaders met on a number of occasions in the aftermath of the Tsilhqot'in win, the Williams case, many of our leaders were celebrating this victory and said, at long last, Canada and British Columbia recognize in every sense of the word, in its full measure, our unextinguished Aboriginal title interests. Grand Chief Ed John said, no. He said, that's not the case. He said, let's be clear. The Supreme Court of Canada recognizes our unextinguished Aboriginal title interests. It's up to us to convince the rest of the country to, you know, to follow through and implement this decision.
So what does have to come to the table? And I ask this because Chief Alphonse from the Tsilhqot'in said, well, if they don't come with a better deal, nothing's happening.
Well, there's no question about that. The Supreme Court has declared Aboriginal title, made a declaration to 1,750 square kilometers of Tsilhqot'in territory, which now is referred to as tidal lands. I've had the privilege and the honor of standing on tidal lands during the many ceremonies and celebrations that have taken place since. You can well imagine that in the aftermath of this decision, there are many, many issues that need to be addressed with respect to the jurisdictional dimension of taking up and owning land in terms of how that land will be managed. And there are countless pieces of legislation and orders in council and policies that need to be revisited in the face of this new reality.
We'll be back in just a moment with more. The views and opinions of guests on this show are not a reflection of the views of the management or staff of this channel. So following the decision, in principle, it is the title land to the Tsilhqot'in, but has title been transferred? Like, is it now like a legal document that says this is yours, and this is the basis by which we start to move forward and then figure out how we work together? Or are we still...
The short answer is yes. The short answer is yes, by virtue of the Supreme Court decision. Being the highest judicial authority in the country, it's the law of the land. As I say, the question now arises, how do we manage title lands? And the province of British Columbia, through the Premier herself, and the leaders of the Tsilhqot'in National Government have signed off on a letter of understanding on initiating a process that will painstakingly address those issues as time unfolds. The question arises, what happens to the balance of British Columbia, which is unceded Aboriginal title lands? The question is, do we slug it out in the courts in every instance for the some 194 First Nations that are not part of the Tsilhqot'in Nation? Or do we negotiate a reasonable approach and process forward? And we had hoped at this historic meeting that took place last week that the Premier would send some unmistakable signals that now is the time to initiate such a process.
But you didn't get those signals.
Well, we have 4 points that we have agreed upon that arose as meetings between all of the leaders, all of the chiefs of the First Nations in the province of British Columbia. We met on April 14th and 15th in Richmond, and there was a follow-up meeting on September the 9th and 10th, the 2 days just before we met with Premier Clark. And what arose out of those 4 days of meetings was 4 points that we brought forward to the Premier on September the 11th.
And what are those 4 points?
Well, those 4 points essentially indicate that there has been a paradigm shift, that we must move beyond this notion of recognition, because the Supreme Court has done that, has answered that question. Now we need to get on with the business of implementing the Supreme Court decision. And that in order to do that, there has to be a complete change in mindset. We need to look at revenue sharing and new fiscal relationships with the province of British Columbia. There needs to be shared decision making, which the courts have called for a very long time. And most importantly, there needs to be an understanding that there has to be a reconciliation between Indigenous legal orders and laws and existing laws and legislation that will come into existence. There's an expectation and an anticipation that the mandates will be changed to reflect the new reality of the Tsilhqot'in decision. But again, that remains to be seen, because we're dealing with governments that are reluctant and very hesitant to follow through. My worldview is a rising tide carries all boats. That once all is said and done, and there is a legislated reconciliation between our land rights and existing rights in the province of British Columbia, there will be, for the very first time in 150 years, economic certainty, and all parties will benefit. And we will look back and wonder, why did this take so long?
Well, but between now and then, there is uncertainty, is there not, for everybody involved?
Yes, until such time as Canada and British Columbia accept the full weight of the reality of the Tsilhqot'in decision and all other Supreme Court decisions that preceded this decision and say, let's quit dancing. Let's sit down and work this out. And we're certainly ready and more than willing to do that.
We'll come back to that in just a moment. Stay with us. The views and opinions of guests on this show are not a reflection of the views of the management or staff of this channel. For companies that are looking at making investments in large-scale projects that depend on the utilization of resources in British Columbia, what's your advice to them right now? Should they wait and see? Should they say there is a path and we can follow that? Or do we go elsewhere?
Well, I think that there are attitudes, unfortunately, and I suppose understandably in this world. There are racist attitudes out there, and certainly we've felt the full brunt of that. My point is, smart companies, smart corporations will, they will understand there has been a seismic shift, and they will engage on that basis.
So from your perspective, it's incumbent upon them to say, I'm not going to come in here and tell you what I'm doing. I'm coming here, first of all, to see whether or not there's an opportunity. Can we explore it? How do we explore it? How do we make that work for everybody? And if that is the environment and the mindset that they come with, is from your perspective, are you and other First Nations saying, okay, we can do business with you?
I think that's probably a pretty fair statement. We're moving from a world of, and again, it goes back to the Supreme Court decisions of consultation to consent. Mm-hmm. There's been a paradigm shift over to the consent side of the equation. Mm-hmm. And again, smart companies and corporations will know and understand that and begin to engage on a more respectful footing, as opposed to thinking they're just going to be able to ram these projects through over the protests of First Nations people. That's not going to happen in today's world. Mm-hmm. And most importantly, we have the law on our side.
Chief Alphonse pointed out, he says, well, we have a great relationship with West Fraser Timber and have had for years. And why? Because they respect us, they respect our right to be here, and we have agreements that work for all parties involved. And so he's saying we're open for business, but it has to be under the right conditions.
Absolutely. I mean, it's common sense.
Are you hopeful about the immediate future? And from that, let's take a look 10, 20 years down the road. Where do you see us at?
Well, I have 14 grandchildren, so I have to be hopeful. I have to be optimistic. But at the same time, I'll be the first one to speak out when government begins to drag its feet. And I'm known for that. But yes, I am. I believe that we will this time. We will learn from our more recent past and realize it's better working together than being in constant opposition and so on and so forth.
And so hopefully we are moving into a time of much greater
I think we are.
Yeah.
I believe that. It's going to take a lot of work, a lot of challenge, leadership. Mm-hmm. We may have changes of government along the way, but we'll get there.
Yeah, on all sides.
Absolutely.
Thank you very much. Appreciate you doing this. To see the complete interview that you've just watched, please join us at our website.